Council of Europe Convention on the Prevention of Terrorism. Signed in Warsaw on 16 May 2005, in force on 1 January 2007. European Treaty Series ETS No. 196. Depositary, Secretary-General of the Council of Europe. The Member States of the Council of Europe and the other signatories hereto. Considering that the aim of the Council of Europe is to achieve greater unity between its members. Recognizing the value of reinforcing cooperation with the other parties to this convention. Wishing to take effective measures to prevent terrorism and to counter, in particular, public provocation to commit terrorist offenses and recruitment and training for terrorism. Aware of the grave concern caused by the increase in terrorist offenses and the growing terrorist threat. Aware of the precarious situation faced by those who suffer from terrorism. And in this connection reaffirming their profound solidarity with the victims of terrorism and their families. Recognizing that terrorist offenses and the offenses set forth in this convention, by whoever perpetrated, are under no circumstances justifiable by considerations of a political, philosophical, ideological, racial, ethnic, religious or other similar nature, and recalling the obligation of all parties to prevent such offenses and, if not prevented, to prosecute and ensure that they are punishable by penalties which take into account their grave nature. Recalling the need to strengthen the fight against terrorism and reaffirming that all measures taken to prevent or suppress terrorist offenses have to respect the rule of law and democratic values, human rights and fundamental freedoms as well as other provisions of international law, including, where applicable, international humanitarian law. Recognizing that this convention is not intended to affect established principles relating to freedom of expression and freedom of association. Recalling that acts of terrorism have the purpose by their nature or context to seriously intimidate a population or unduly compel a government or an international organization to perform or abstain from performing any act or seriously destabilize or destroy the fundamental political, constitutional, economic or social structures of a country or an international organization. Have agreed as follows. Article 1, Terminology. 1. For the purposes of this convention, terrorist offense means any of the offenses within the scope of and as defined in one of the treaties listed in the appendix. 2. On depositing its instrument of ratification, acceptance, approval or accession, a state or the European Community which is not a party to a treaty listed in the appendix may declare that, in the application of this convention to the party concerned, that treaty shall be deemed not to be included in the appendix. This declaration shall cease to have effect as soon as the treaty enters into force for the party having made such a declaration, which shall notify the Secretary-General of the Council of Europe of this entry into force. Article 2, Purpose. The purpose of the present convention is to enhance the efforts of parties in preventing terrorism and its negative effects on the full enjoyment of human rights, in particular the right to life, both by measures to be taken at national level and through international cooperation, with due regard to the existing applicable multilateral or bilateral treaties or agreements between the parties. Article 3, National Prevention Policies. 1. Each party shall take appropriate measures, particularly in the field of training of law enforcement authorities and other bodies, and in the fields of education, culture, information, media and public awareness raising, with a view to preventing terrorist offenses and their negative effects while respecting human rights obligations as set forth in, where applicable to that party, the Convention for the Protection of Human Rights and Fundamental Freedoms, the International Covenant on Civil and Political Rights, and other obligations under international law. 2. Each party shall take such measures as may be necessary to improve and develop the cooperation among national authorities with a view to preventing terrorist offenses and their negative effects by, inter alia, a. Exchanging information. b. Improving the physical protection of persons and facilities. c. enhancing training and coordination plans for civil emergencies. 3. Each party shall promote tolerance by encouraging inter-religious and cross-cultural dialogue involving, where appropriate, non-governmental organizations and other elements of civil society with a view to preventing tensions that might contribute to the commission of terrorist offenses. 4. Each party shall endeavor to promote public awareness regarding the existence, causes and gravity of and the threat posed by terrorist offenses and the offenses set forth in this convention, and consider encouraging the public to provide factual, specific help to its competent authorities that may contribute to preventing terrorist offenses and offenses set forth in this convention. Article 4. International cooperation on prevention. Parties shall, as appropriate and with due regard to their capabilities, assist and support each other with a view to enhancing their capacity to prevent the commission of terrorist offenses, including through exchange of information and best practices, as well as through training and other joint efforts of a preventive character. Article 5. Public provocation to commit terrorist offense. 1. For the purposes of this convention, public provocation to commit terrorist offense means the distribution, or otherwise making available, of a message to the public, with the intent to incite the commission of a terrorist offense, where such conduct, whether or not directly advocating terrorist offenses, causes a danger that one or more such offenses may be committed. 2. Each party shall adopt such measures as may be necessary to establish public provocation to commit terrorist offense, as defined in paragraph 1, when committed unlawfully and intentionally, as a criminal offense under its domestic law. Article 6. Recruitment for terrorism. 1. For the purposes of this convention, recruitment for terrorism means to solicit another person to commit or participate in the commission of a terrorist offense, or to join an association or group, for the purpose of contributing to the commission of one or more terrorist offenses by the association or the group. 2. Each party shall adopt such measures as may be necessary to establish recruitment for terrorism, as defined in paragraph 1, when committed unlawfully and intentionally, as a criminal offense under its domestic law. Article 7. Training for terrorism. 1. For the purposes of this convention, training for terrorism means to provide instruction in the making or use of explosives, firearms or other weapons or noxious or hazardous substances, or in other specific methods or techniques, for the purpose of carrying out or contributing to the commission of a terrorist offense, knowing that the skills provided are intended to be used for this purpose. 2. Each party shall adopt such measures as may be necessary to establish training for terrorism, as defined in paragraph 1, when committed unlawfully and intentionally, as a criminal offense under its domestic law. Article 8. Irrelevance of the commission of a terrorist offense. For an act to constitute an offense as set forth in Articles 5 to 7 of this convention, it shall not be necessary that a terrorist offense be actually committed. Article 9. Ancillary offenses. 1. Each party shall adopt such measures as may be necessary to establish as a criminal offense under its domestic law, a. Participating as an accomplice in an offense as set forth in Articles 5 to 7 of this convention, b. Organizing or directing others to commit an offense as set forth in Articles 5 to 7 of this convention, c. Contributing to the commission of one or more offenses as set forth in Articles 5 to 7 of this convention by a group of persons acting with a common purpose. Such contribution shall be intentional and shall either I. Be made with the aim of furthering the criminal activity or criminal purpose of the group, where such activity or purpose involves the commission of an offense as set forth in Articles 5 to 7 of this convention, or 2. Be made in the knowledge of the intention of the group to commit an offense as set forth in Articles 5 to 7 of this convention. 2. Each party shall also adopt such measures as may be necessary to establish as a criminal offense under, and in accordance with, its domestic law the attempt to commit an offense as set forth in Articles 6 and 7 of this convention. Article 10, Liability of legal entities. 1. Each party shall adopt such measures as may be necessary, in accordance with its legal principles, to establish the liability of legal entities for participation in the offences set forth in Articles 5 to 7 and 9 of this Convention. 2. Subject to the legal principles of the party, the liability of legal entities may be criminal, civil or administrative. 3. Such liability shall be without prejudice to the criminal liability of the natural persons who have committed the offences. Article 11. Sanctions and measures. 1. Each party shall adopt such measures as may be necessary to make the offences set forth in Articles 5 to 7 and 9 of this Convention punishable by effective, proportionate and dissuasive penalties. 2. Previous final convictions pronounced in foreign states for offences set forth in the present Convention may, to the extent permitted by domestic law, be taken into account for the purpose of determining the sentence in accordance with domestic law. 3. Each party shall ensure that legal entities held liable in accordance with Article 10 are subject to effective, proportionate and dissuasive criminal or non-criminal sanctions, including monetary sanctions. Article 12, Conditions and Safeguards. 1. Each party shall ensure that the establishment, implementation and application of the criminalization under Articles 5 to 7 and 9 of this Convention are carried out while respecting human rights obligations, in particular the right to freedom of expression, freedom of association and freedom of religion, as set forth in, where applicable to that party, the Convention for the Protection of Human Rights and Fundamental Freedoms, the International Covenant on Civil and Political Rights, and other obligations under international law. 2. The establishment, implementation and application of the criminalization under Articles 5 to 7 and 9 of this Convention should furthermore be subject to the principle of proportionality, with respect to the legitimate aims pursued and to their necessity in a democratic society, and should exclude any form of arbitrariness or discriminatory or racist treatment. Article 13, Protection, Compensation and Support for Victims of Terrorism. Each party shall adopt such measures as may be necessary to protect and support the victims of terrorism that has been committed within its own territory. These measures may include, through the appropriate national schemes and subject to domestic legislation, inter alia, financial assistance and compensation for victims of terrorism and their close family members. Article 14, Jurisdiction. 1. Each party shall take such measures as may be necessary to establish its jurisdiction over the offences set forth in this Convention. A. When the offence is committed in the territory of that party. B. When the offence is committed on board a ship flying the flag of that party, or on board an aircraft registered under the laws of that party. C. When the offence is committed by a national of that party. 2. Each party may also establish its jurisdiction over the offences set forth in this Convention. A. When the offence was directed towards or resulted in the carrying out of an offence referred to in Article 1 of this Convention, in the territory of or against a national of that party. B. When the offence was directed towards or resulted in the carrying out of an offence referred to in Article 1 of this Convention, against a state or government facility of that party abroad, including diplomatic or consular premises of that party. C. When the offence was directed towards or resulted in an offence referred to in Article 1 of this Convention, committed in an attempt to compel that party to do or abstain from doing any act. D. When the offence is committed by a stateless person who has his or her habitual residence in the territory of that party. E. When the offence is committed on board an aircraft which is operated by the government of that party. 3. Each party shall take such measures as may be necessary to establish its jurisdiction over the offences set forth in this convention in the case where the alleged offender is present in its territory and it does not extradite him or her to a party whose jurisdiction is based on a rule of jurisdiction existing equally in the law of the requested party. 4. This convention does not exclude any criminal jurisdiction exercised in accordance with national law. 5. When more than one party claims jurisdiction over an alleged offense set forth in this convention, the parties involved shall, where appropriate, consult with a view to determining the most appropriate jurisdiction for prosecution. Article 15. Duty to investigate. 1. Upon receiving information that a person who has committed or who is alleged to have committed an offense set forth in this convention may be present in its territory, the party concerned shall take such measures as may be necessary under its domestic law to investigate the facts contained in the information. 2. Upon being satisfied that the circumstances so warrant, the party in whose territory the offender or alleged offender is present shall take the appropriate measures under its domestic law so as to ensure that person's presence for the purpose of prosecution or extradition. 3. Any person in respect of whom the measures referred to in paragraph 2 are being taken shall be entitled to a. Communicate without delay with the nearest appropriate representative of the state of which that person is a national or which is otherwise entitled to protect that person's rights or, if that person is a stateless person, the state in the territory of which that person habitually resides. b. Be visited by a representative of that state. c. Be informed of that person's rights under subparagraphs a and b. 4. The rights referred to in paragraph 3 shall be exercised in conformity with the laws and regulations of the party in the territory of which the offender or alleged offender is present, subject to the provision that the said laws and regulations must enable full effect to be given to the purposes for which the rights accorded under paragraph 3 are intended. 5. The provisions of paragraphs 3 and 4 shall be without prejudice to the right of any party having a claim of jurisdiction in accordance with Article 14, paragraphs 1, c, and 2, d, to invite the International Committee of the Red Cross to communicate with and visit the alleged offender. Article 16. Non-application of the Convention. This convention shall not apply where any of the offences established in accordance with Articles 5 to 7 and 9 is committed within a single state, the alleged offender is a national of that state and is present in the territory of that state, and no other state has a basis under Article 14, paragraph 1 or 2 of this convention, to exercise jurisdiction, it being understood that the provisions of Articles 17 and 20 to 22 of this convention shall, as appropriate, apply in those cases. Article 17. International cooperation in criminal matters. 1. Parties shall afford one another the greatest measure of assistance in connection with criminal investigations or criminal or extradition proceedings in respect of the offences set forth in Articles 5 to 7 and 9 of this convention, including assistance in obtaining evidence in their possession necessary for the proceedings. 2. Parties shall carry out their obligations under paragraph 1 in conformity with any treaties or other agreements on mutual legal assistance that may exist between them. In the absence of such treaties or agreements, parties shall afford one another assistance in accordance with their domestic law. 3. Parties shall cooperate with each other to the fullest extent possible under relevant law, treaties, agreements and arrangements of the requested party with respect to criminal investigations or proceedings in relation to the offences for which a legal entity may be held liable in accordance with Article 10 of this convention in the requesting party. 4. Each party may give consideration to establishing additional mechanisms to share with other parties information or evidence needed to establish criminal, civil or administrative liability pursuant to Article 10. Article 18. Extradite or prosecute. 1. The party in the territory of which the alleged offender is present shall, when it has jurisdiction in accordance with Article 14, if it does not extradite that person, be obliged, without exception whatsoever and whether or not the offense was committed in its territory, to submit the case without undue delay to its competent authorities for the purpose of prosecution, through proceedings in accordance with the laws of that party. Those authorities shall take their decision in the same manner as in the case of any other offense of a serious nature under the law of that party. 2. Whenever a party is permitted under its domestic law to extradite or otherwise surrender one of its nationals only upon the condition that the person will be returned to that party to serve the sentence imposed as a result of the trial or proceeding for which the extradition or surrender of the person was sought, and this party and the party seeking the extradition of the person agree with this option and other terms they may deem appropriate, such a conditional extradition or surrender shall be sufficient to discharge the obligation set forth in paragraph 1. Article 19, Extradition, 1. The offences set forth in Articles 5 to 7 and 9 of this Convention shall be deemed to be included as extraditable offences in any extradition treaty existing between any of the parties before the entry into force of this Convention. Parties undertake to include such offences as extraditable offences in every extradition treaty to be subsequently concluded between them. 2. When a party which makes extradition conditional on the existence of a treaty receives a request for extradition from another party with which it has no extradition treaty, the requested party may, if it so decides, consider this convention as a legal basis for extradition in respect of the offences set forth in Articles 5 to 7 and 9 of this convention. Extradition shall be subject to the other conditions provided by the law of the requested party. 3. Parties which do not make extradition conditional on the existence of a treaty shall recognize the offences set forth in Articles 5 to 7 and 9 of this convention as extraditable offences between themselves, subject to the conditions provided by the law of the requested party. 4. Where necessary, the offences set forth in Articles 5 to 7 and 9 of this convention shall be treated, for the purposes of extradition between parties, as if they had been committed not only in the place in which they occurred but also in the territory of the parties that have established jurisdiction in accordance with Article 14. 5. The provisions of all extradition treaties and agreements concluded between parties in respect of offences set forth in Articles 5 to 7 and 9 of this convention shall be deemed to be modified as between parties to the extent that they are incompatible with this convention. Article 20, Exclusion of the Political Exception Clause, 1. None of the offences referred to in Articles 5 to 7 and 9 of this convention shall be regarded, for the purposes of extradition or mutual legal assistance, as a political offense, an offense connected with a political offense, or as an offense inspired by political motives. Accordingly, a request for extradition or for mutual legal assistance based on such an offense may not be refused on the sole ground that it concerns a political offense or an offense connected with a political offense or an offense inspired by political motives. 2. Without prejudice to the application of Articles 19 to 23 of the Vienna Convention on the Law of Treaties of the 23rd of May 1969 to the other articles of this convention, any state or the European Community may, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession of the convention, declare that it reserves the right to not apply paragraph 1 of this article as far as extradition in respect of an offense set forth in this convention is concerned. The party undertakes to apply this reservation on a case-by-case basis, through a duly reasoned decision. 3. Any party may wholly or partly withdraw a reservation it has made in accordance with paragraph 2 by means of a declaration addressed to the Secretary-General of the Council of Europe which shall become effective as from the date of its receipt. 4. A party which has made a reservation in accordance with paragraph 2 of this article may not claim the application of paragraph 1 of this article by any other party. It may, however, if its reservation is partial or conditional, claim the application of this article insofar as it has itself accepted it. 5. The reservation shall be valid for a period of 3 years from the day of the entry into force of this convention in respect of the party concerned. However, such reservation may be renewed for periods of the same duration. 6. 12 months before the date of expiry of the reservation, the Secretary-General of the Council of Europe shall give notice of that expiry to the party concerned. No later than 3 months before expiry, the party shall notify the Secretary-General of the Council of Europe that it is upholding, amending or withdrawing its reservation. Where a party notifies the Secretary-General of the Council of Europe that it is upholding its reservation, it shall provide an explanation of the grounds justifying its continuance. In the absence of notification by the party concerned, the Secretary-General of the Council of Europe shall inform that party that its reservation is considered to have been extended automatically for a period of 6 months. Failure by the party concerned to notify its intention to uphold or modify its reservation before the expiry of that period shall cause the reservation to lapse. 7. Where a party does not extradite a person in application of this reservation, after receiving an extradition request from another party, it shall submit the case, without exception whatsoever and without undue delay, to its competent authorities for the purpose of prosecution, unless the requesting party and the requested party agree otherwise. The competent authorities, for the purpose of prosecution in the requested party, shall take their decision in the same manner as in the case of any offense of a grave nature under the law of that party. The requested party shall communicate, without undue delay, the final outcome of the proceedings to the requesting party and to the Secretary-General of the Council of Europe, who shall forward it to the consultation of the parties provided for in Article 30. 8. The decision to refuse the extradition request on the basis of this reservation shall be forwarded promptly to the requesting party. If within a reasonable time no judicial decision on the merits has been taken in the requested party according to paragraph 7, the requesting party may communicate this fact to the Secretary-General of the Council of Europe, who shall submit the matter to the consultation of the parties provided for in Article 30. This consultation shall consider the matter and issue an opinion on the conformity of the refusal with the Convention and shall submit it to the Committee of Ministers for the purpose of issuing a declaration thereon. When performing its functions under this paragraph, the Committee of Ministers shall meet in its composition restricted to the states parties. Article 21, Discrimination Clause, 1. Nothing in this convention shall be interpreted as imposing an obligation to extradite or to afford mutual legal assistance, if the requested party has substantial grounds for believing that the request for extradition for offences set forth in Articles 5 to 7 and 9 or for mutual legal assistance with respect to such offences has been made for the purpose of prosecuting or punishing a person on account of that person's race, religion, nationality, ethnic origin or political opinion, or that compliance with the request would cause prejudice to that person's position for any of these reasons. 2. Nothing in this convention shall be interpreted as imposing an obligation to extradite if the person who is the subject of the extradition request risks being exposed to torture or to inhuman or degrading treatment or punishment. 3. Nothing in this convention shall be interpreted either as imposing an obligation to extradite if the person who is the subject of the extradition request risks being exposed to the death penalty, or, where the law of the requested party does not allow for life imprisonment, to life imprisonment without the possibility of parole, unless under applicable extradition treaties the requested party is under the obligation to extradite if the requesting party gives such assurance as the requested party considers sufficient that the death penalty will not be imposed or, where imposed, will not be carried out, or that the person concerned will not be subject to life imprisonment without the possibility of parole. Article 22. Spontaneous information. 1. Without prejudice to their own investigations or proceedings, the competent authorities of a party may, without prior request, forward to the competent authorities of another party information obtained within the framework of their own investigations, when they consider that the disclosure of such information might assist the party receiving the information in initiating or carrying out investigations or proceedings, or might lead to a request by that party under this convention. 2. The party providing the information may, pursuant to its national law, impose conditions on the use of such information by the party receiving the information. 3. The party receiving the information shall be bound by those conditions. 4. However, any party may, at any time, by means of a declaration addressed to the Secretary-General of the Council of Europe, declare that it reserves the right not to be bound by the conditions imposed by the party providing the information under paragraph 2 above, unless it receives prior notice of the nature of the information to be provided and agrees to its transmission. Article 23, Signature and Entry into Force. 1. This convention shall be open for signature by the member states of the Council of Europe, the European Community, and by non-member states which have participated in its elaboration. 2. This convention is subject to ratification, acceptance or approval. Instruments of ratification, acceptance or approval shall be deposited with the Secretary-General of the Council of Europe. 3. This convention shall enter into force on the first day of the month following the expiration of a period of 3 months after the date on which 6 signatories, including at least 4 member states of the Council of Europe, have expressed their consent to be bound by the convention in accordance with the provisions of paragraph 2. 4. In respect of any signatory which subsequently expresses its consent to be bound by it, the convention shall enter into force on the first day of the month following the expiration of a period of 3 months after the date of the expression of its consent to be bound by the convention in accordance with the provisions of paragraph 2. Article 24, Accession to the Convention. 1. After the entry into force of this convention, the Committee of Ministers of the Council of Europe, after consulting with and obtaining the unanimous consent of the parties to the convention, may invite any state which is not a member of the Council of Europe and which has not participated in its elaboration to accede to this convention. The decision shall be taken by the majority provided for in Article 20(d) of the Statute of the Council of Europe and by the unanimous vote of the representatives of the parties entitled to sit on the Committee of Ministers. 2. In respect of any state acceding to the convention under paragraph 1 above, the convention shall enter into force on the first day of the month following the expiration of a period of 3 months after the date of deposit of the instrument of accession with the Secretary-General of the Council of Europe. Article 25, Territorial Application. 1. Any state or the European Community may, at the time of signature or when depositing its instrument of ratification, acceptance, approval or accession, specify the territory or territories to which this convention shall apply. 2. Any party may, at any later date, by a declaration addressed to the Secretary-General of the Council of Europe, extend the application of this convention to any other territory specified in the declaration. In respect of such territory the convention shall enter into force on the first day of the month following the expiration of a period of 3 months after the date of receipt of the declaration by the Secretary-General. 3. Any declaration made under the 2 preceding paragraphs may, in respect of any territory specified in such declaration, be withdrawn by a notification addressed to the Secretary-General of the Council of Europe. The withdrawal shall become effective on the first day of the month following the expiration of a period of 3 months after the date of receipt of such notification by the Secretary-General. Article 26. Effects of the Convention. 1. The present convention supplements applicable multilateral or bilateral treaties or agreements between the parties, including the provisions of the following Council of Europe treaties. A European Convention on Extradition, opened for signature, in Paris, on 13 December 1957, ETS number 24. A European Convention on Mutual Assistance in Criminal Matters, opened for signature, in Strasbourg, on 20 April 1959, ETS number 30. A European Convention on the Suppression of Terrorism, opened for signature, in Strasbourg, on 27 January 1977, ETS number 90. A additional protocol to the European Convention on Mutual Assistance in Criminal Matters, opened for signature in Strasbourg on 17 March 1978, ETS number 99. A second additional protocol to the European Convention on Mutual Assistance in Criminal Matters, opened for signature in Strasbourg on 8 November 2001, ETS number 182. A protocol amending the European Convention on the Suppression of Terrorism, opened for signature in Strasbourg on 15 May 2003, ETS number 190. 2. If two or more parties have already concluded an agreement or treaty on the matters dealt with in this convention or have otherwise established their relations on such matters, or should they in future do so, they shall also be entitled to apply that agreement or treaty or to regulate those relations accordingly. However, where parties establish their relations in respect of the matters dealt with in the present convention other than is regulated therein, they shall do so in a manner that is not inconsistent with the convention's objectives and principles. 3. Parties which are members of the European Union shall, in their mutual relations, apply Community and European Union rules insofar as there are Community or European Union rules governing the particular subject concerned and applicable to the specific case, without prejudice to the object and purpose of the present convention and without prejudice to its full application with other parties. 4. Nothing in this convention shall affect other rights, obligations and responsibilities of a party and individuals under international law, including international humanitarian law. 5. The activities of armed forces during an armed conflict, as those terms are understood under international humanitarian law, which are governed by that law, and not governed by this convention, and the activities undertaken by military forces of a party in the exercise of their official duties, inasmuch as they are governed by other rules of international law, and not governed by this convention. Article 27, Amendments to the Convention. 1. Amendments to this convention may be proposed by any party, the Committee of Ministers of the Council of Europe or the consultation of the parties. 2. Any proposal for amendment shall be communicated by the Secretary-General of the Council of Europe to the parties. 3. Moreover, any amendment proposed by a party or the Committee of Ministers shall be communicated to the consultation of the parties, which shall submit to the Committee of Ministers its opinion on the proposed amendment. 4. The Committee of Ministers shall consider the proposed amendment and any opinion submitted by the consultation of the parties and may approve the amendment. 5. The text of any amendment approved by the Committee of Ministers in accordance with paragraph 4 shall be forwarded to the parties for acceptance. 6. Any amendment approved in accordance with paragraph 4 shall come into force on the 30th day after all parties have informed the Secretary-General of their acceptance thereof. Article 28, Revision of the Appendix. 1. In order to update the list of treaties in the Appendix, amendments may be proposed by any party or by the Committee of Ministers. These proposals for amendment shall only concern universal treaties concluded within the United Nations system dealing specifically with international terrorism and having entered into force. They shall be communicated by the Secretary-General of the Council of Europe to the parties. 2. After having consulted the non-member parties, The Committee of Ministers may adopt a proposed amendment by the majority provided for in Article 20(d) of the Statute of the Council of Europe. The amendment shall enter into force following the expiry of a period of 1 year after the date on which it has been forwarded to the parties. During this period, any party may notify the Secretary-General of the Council of Europe of any objection to the entry into force of the amendment in respect of that party. 3. If 1/3 of the parties notifies the Secretary-General of the Council of Europe of an objection to the entry into force of the amendment shall not enter into force. 4. If less than 1/3 of the parties notifies an objection, the amendment shall enter into force for those parties which have not notified an objection. 5. Once an amendment has entered into force in accordance with paragraph 2 and a party has notified an objection to it, this amendment shall come into force in respect of the party concerned on the first day of the month following the date on which it notifies the Secretary-General of the Council of Europe of its acceptance. Article 29, Settlement of Disputes. In the event of a dispute between parties as to the interpretation or application of this convention, they shall seek a settlement of the dispute through negotiation or any other peaceful means of their choice, including submission of the dispute to an arbitral tribunal whose decisions shall be binding upon the parties to the dispute, or to the International Court of Justice, as agreed upon by the parties concerned. Article 30, Consultation of the parties. 1. The parties shall consult periodically with a view to a. Making proposals to facilitate or improve the effective use and implementation of this convention, including the identification of any problems and the effects of any declaration made under this convention. b. Formulating its opinion on the conformity of a refusal to extradite which is referred to them in accordance with Article 20, paragraph 8. c. Making proposals for the amendment of this convention in accordance with Article 27. d. Formulating their opinion on any proposal for the amendment of this convention which is referred to them in accordance with Article 27, paragraph 3. e. Expressing an opinion on any question concerning the application of this convention and facilitating the exchange of information on significant legal, policy or technological developments. 2. The consultation of the parties shall be convened by the Secretary-General of the Council of Europe whenever he finds it necessary and in any case when a majority of the parties or the Committee of Ministers request its convocation. 3. The parties shall be assisted by the Secretariat of the Council of Europe in carrying out their functions pursuant to this article. Article 31 Denunciation 1. Any party may, at any time, denounce this convention by means of a notification addressed to the Secretary-General of the Council of Europe. 2. Such denunciation shall become effective on the first day of the month following the expiration of a period of 3 months after the date of receipt of the notification by the Secretary-General. Article 32. Notification. The Secretary-General of the Council of Europe shall notify the Member States of the Council of Europe, the European Community, the non-member states which have participated in the elaboration of this convention as well as any state which has acceded to, or has been invited to accede to, this convention of a. Any signature. b. The deposit of any instrument of ratification, acceptance, approval or accession. c. Any date of entry into force of this convention in accordance with Article 23. d. Any declaration made under Article 1, paragraph 2, 22, paragraph 4, and 25. e. Any other act, notification or communication relating to this convention, in witness whereof the undersigned, being duly authorized thereto, have signed this convention. Done at Warsaw, this 16th day of May 2005, in English and in French, both texts being equally authentic, in a single copy which shall be deposited in the archives of the Council of Europe. The Secretary-General of the Council of Europe shall transmit certified copies to each member state of the Council of Europe, to the European Community, to the non-member states which have participated in the elaboration of this convention, and to any state invited to accede to it. Appendix 1. Convention for the Suppression of Unlawful Seizure of Aircraft, signed at The Hague on 16 December 1970. 2. Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation, concluded at Montreal on 23 September 1971. 3. Convention on the Prevention and Punishment of Crimes Against Internationally Protected Persons, including diplomatic agents, adopted in New York on 14 December 1973. 4. International Convention Against the Taking of Hostages, adopted in New York on 17 December 1979. 5. Convention on the Physical Protection of Nuclear Material, adopted in Vienna on 3 March 1980. 6. Protocol for the Suppression of Unlawful Acts of Violence at Airports Serving International Civil Aviation, done at Montreal on 24 February 1988. 7. Convention for the Suppression of Unlawful Acts Against the Safety of Maritime Navigation, done at Rome on 10 March 1988. 8. Protocol for the Suppression of Unlawful Acts Against the Safety of Fixed Platforms Located on the Continental Shelf, done at Rome on 10 March 1988. 9. International Convention for the Suppression of Terrorist Bombings, adopted in New York on 15 December 1997. 10. International Convention for the Suppression of the Financing of Terrorism, adopted in New York on 9 December 1999.